Hi, everyone. Thank you so much for joining us in this CLE with Randy Turner, animal law attorney. We're really excited to have you all. We are just going to get started in just a few seconds. All right, it is 12:01, so we're going to get started. My name is Katie Resnick. I'm a co-chair for the Animal Welfare Committee for DAYL, and we are super excited to have Mr. Randy Turner here to talk to us today in this CLE presentation. And Randy is incredible. I've had the opportunity to meet with him. He's an amazing animal law attorney. And so let me give you a little bit of background, and then Randy will take it away. So Randy Turner practices animal law in Fort Worth. He is a co-founder and past chair of the Animal Law section of the State Bar of Texas. He is a past president and current board member of the Texas Humane Legislation Network and past vice president of the Humane Society of North Texas. He has worked as a volunteer in Borneo, Indonesia, on an orangutan rescue and rehabilitation, in Kenya on an elephant conservation, and in Zimbabwe on a black rhino conservation. Randy has been representing animal rescues and welfare organizations, wildlife sanctuaries, animal rights activists, and animal owners all over Texas for the past 40 years. He is a frequent lecturer on animal law and regularly testifies at the Texas legislature on bills affecting animals. Randy alternates his time between Fort Worth and a beautiful cabin in Colorado with his 2 rescue dogs and his 2 rescue cats. Randy, thank you so much for being with us today. We're really looking forward to this, and take it away.
Well, thanks, Katie. Thank you for inviting me. I hope today's presentation is interesting. I'm covering quite a bit. Actually, this PowerPoint I did is it's 3 PowerPoints that are 1 hour long each that I often present, and I'm cramming them into 1 hour. So I'm just going to kind of highlight the things here. I almost feel like I'm giving a 1 hour talk on tort law, contract law, and property law. But let me first start with first I'm going to start with service assistance and emotional support animals, and those are not the same thing. They're 3 different things. This is probably the single most misunderstood area of law that I'm aware of. If you call 100 lawyers, you might find 1 who knows the difference between a service animal and an emotional support animal, but it's very widely misunderstood by the public and lawyers. And hopefully 30 minutes from now, you're gonna have a good handle on these issues. So here are the statutes that apply to service assistance and emotional support animals. There are federal statutes and there are state statutes. Federal law says that states can enact disability statutes as long as they give disabled people more rights or equal rights. The Texas statutes, we have 3: the Health and Human Resources Code, the Labor Code, the Health and Safety Code, 4 in the Fair Housing Act. When I litigate these cases, I always file suit in state court because, for one thing, I don't like federal court because the judge has too much control over your case. I much prefer state court, although I guess you could sometimes get better juries in federal court. So these are the statutes. Now, everyone knows about the Federal Americans with Disabilities Act. That's the one that everybody knows about. It governs places open to the public and the workplace. The Air Carrier Access Act governs animals on airplanes, and then the Fair Housing Act is animals in housing. So here's if you don't remember anything from my whole talk, I hope you remember this. none of these statutes apply unless the person has a disability, a physical or a mental disability. If there's not a physical or mental disability, then forget all these statutes. ADA doesn't apply, Air Carrier Access Act, Fair Housing Act. So the very first question that you need to ask if somebody wants to bring an animal into a place is, do they have a physical or mental disability? And you can see there the definition is an impairment that substantially limits a major life activity. And if you look at the examples below, it covers almost everything: taking care of yourself, walking, standing, thinking, breathing, or if you have a disability of a major bodily function, such as immune system, bowel, bladder, neurological. So the very first thing is, does the person have a mental or physical disability? Now, it has to have lasted or be expected to last for at least 6 months. And it has to be an actual disability. You can't, so a person can't say, well, I was fired from my job, my spouse is divorcing me, I'm depressed, therefore I'm going to take an emotional support animal with me. No, it's got to be 6 months. And if you want to be safe, you really need a healthcare provider to diagnose it and to say that you need a service or an assistance animal. Here are the two. Oh, great. Uh-oh. Let me change I hit a button and I'm not very good. Oh, okay, here we go. There are two types of animals in this area: service animals and emotional support animals. They're not the same. Service animals are animals that are individually trained to perform a task for somebody with a disability, and it's related to their disability. The training can be done by the owner. The animal doesn't have to be trained by a professional. An emotional support animal, on the other hand, is an animal whose presence provides emotional support and comfort for a disabled person, but the animal is not individually trained to perform any particular tasks. So service animal, the most obvious example is a seeing eye dog for a blind person. And before I got into this, that was really kind of the only service animal that I knew about. But as I've gotten into this, it is absolutely incredible what these service animals are trained to do. There's a member of your section whose mom is Cindy Smiley in Austin, and she's involved with training these animals. I'll just give you some examples. There are dogs that are trained to alert a person to their low blood sugar, to detect allergens in foods, to alert a deaf person to a doorbell, a phone, an alarm. And each of those has different signals. So when the dog alerts the deaf person knows, oh, it's my alarm, or it's the doorbell, depending on how the dog acts. These dogs can sense panic attacks. I mean, there's some people with PTSD that can have sudden onset of panic attacks. And these dogs are trained to, they can tell when one is about to come. And so they'll jump up and lick the owner's face and do various things. And of course, they can open doors. They can get clothes out of the dryer. They can hand the charge card to the cashier at the store. I mean, it's just amazing what service animals do. But the key is service animals are trained. They do a certain job related to the disability. Emotional support animal, the person has to be disabled, but the animal doesn't do anything. I mean, doesn't do any tasks related to the disability. There is no law that says service animals or emotional support animals have to be registered, certified, licensed, wear a vest, or be trained by a professional. So I get people all the time calling me and telling me that, well, I'm disabled and my service dog is registered, he's certified. Well, what that tells me is this person paid a bunch of money to a company on the internet to buy a certificate or a registration or a vest. I mean, they're all over the internet. But these things are not needed. There's no law that requires that. As a matter of fact, I'm handling a case right now. Well, I'll get to that in a minute. But so they have various kits. You know, you can buy a kit with just ID cards and a vest, or you can add registration cards. These are just a total waste of money. Okay, so I'm going to talk about different places where people want to take their dogs, starting with places open to the public. This is the most people know about the ADA, and the ADA controls the laws. It has the laws pertaining to public accommodations or places open to the public. And the rule is service animals must be allowed in all places open to the public. Service animals, and they can only be dogs and miniature horses. I've never seen a miniature horse service animal, but they tell me they're out there. No emotional support animals. So this is huge. You see people trying to bring their emotional support animal into a grocery store, a movie theater, an office. It's not allowed. It has to be a trained service animal, trained dog or miniature horse. And they can go anywhere. I mean, anywhere. They can go into stores, restaurants, theaters, gyms, hotels, hospitals. I'm currently involved in a lawsuit against a hospital that refused to allow my client's service dog to go into the hospital. She's got a cardiac condition, and basically what they were arguing is, well, you don't need the dog in a hospital. Well, she really did. She's got a cardiac condition that her dog jumps up on her and puts its paws. Somehow it regulates her cardiovascular movement of blood. So they can go anywhere that people can go. And restaurants can't make them. I've got another lawsuit going on against a restaurant where they said, we don't allow dogs. You can sit outside. Nope, that's a violation of the law. And there's a private cause of action. You can file suit for damages if they try to make you, if they don't let you in, or they make you sit in a separate area or sit outside. Again, no documentation, vest, ID, et cetera, is needed. And this is important. A facility is only allowed to ask two questions. Number one, is the animal needed because of a disability? And number two, what tasks is the animal trained to perform? If they ask any other questions, a lawsuit can be filed against them for damages, and there's a presumption of damages. So if the facility says, what kind of disability do you have? Nope, that's a violation of the law. I mean, so this is huge. The main things you need to remember, just service animals, not emotional support, and only those two questions can be asked. Now, there are rules that also apply. Animals have to be housebroken and under control. The facility can require the person to keep the animal on a leash unless that's going to interfere with the animal's tasks, how it performs its job. And facilities don't have to fundamentally alter their services or program. I mean, if they can't accommodate dogs without spending $25,000 to modify their premises, they don't have to do that. So it's not absolute. It's sort of a reasonableness standard. And I had another client that she couldn't keep her dog on a leash because she used the dog for balance. And she said that the balance, the leash wouldn't work if in her situation. So anyway, those are the important rules about going into places open to the public. Now let me mention that when you see an animal in a restaurant wearing a service vest and it's jumping up on people, it's lifting its leg furniture. It's barking at other dogs or people. I guarantee that's not a genuine service dog. Service dogs are trained like you wouldn't believe. A friend of mine told me that the service dogs can cost up to $80,000 to train. Now, disabled people generally, there are lots of nonprofits out there that raise money and train service animals, and they give them to disabled people for free or for a nominal fee. But anyway, the point is, if you see a dog misbehaving in a restaurant or a store, it's not going to be a service dog. And service dogs are trained. The very first thing they learn is you don't jump up or disturb or bark or do anything like that. Okay, what if a person falsely represents that a pet is a service animal, which happens all the time? And it's a huge problem because it punishes genuinely disabled people with real service dogs because people trying to take their dog in as their pet and pass him off as a service dog. Now, under the ADA, there's no penalty. Texas has a $1,000 fine and 30 hours of community service penalty, which I'm happy to say that THLN, the Texas Humane Legislation Network, we got it passed in the last session. We go down there and lobby and try to get laws passed. So we got this one passed. So I'm not aware of anybody being prosecuted for that yet, but it's on the books, and hopefully it's going to deter people from trying to take their pets into places open to the public. Now, the next one I want to talk about is housing. So these are totally different rules. This is the Fair Housing Act. You have the U.S. Fair Housing Act and the Texas Fair Housing Act. Here are the rules. They have to allow assistance animals. Housing providers have to allow assistance animals. And those include trained service dogs and support animals. Now, the support animals, they can be emotional support animals, or they can be trained or untrained animals other than dogs. So if you've got a support animal, for example, an emotional support animal, the law breaks it down into two categories. If it's a common household animal, then it can qualify as an emotional support animal. Dogs, cats, turtles, birds, gerbils, fish, rabbits, they automatically can qualify as a support animal. Now, unique animals are those which are not commonly kept in the home: monkey, goat, kangaroo, etc. Now, they can still qualify as an emotional support animal, but the disabled person has a substantial burden to show that they need that specific type of animal. So I have a war story. So you wonder, well, how does this come up? Okay, so I had a client. We just settled her case. She had a young mother and her husband. They had two disabled children. The kids had severe autism. There was a 12-year-old girl who was intellectually challenged and autistic. She wouldn't leave her room. She had the cognitive ability of like a 5-year-old. And then they had a younger boy who was like 6 years old, and he had behavioral autism. What he would do is 15 or 20 times a day, he would just lie down on the floor and start kicking and screaming at the top of his lungs and pounding the floor, and he would just have these fits. Well, they had tried everything to sort of alleviate these, to help these kids. Both the kids are going to a neurologist, psychiatrist. So they had tried dogs, cats, rabbits, and they might have tried hamsters. Nothing worked. One day, the dad came home with two miniature pigs, Wally and can't remember the other one's name. But it was like a miracle cure. These kids took to these pigs, and the 12-year-old girl would, if her each kid had a pig. I think hers was Wally. If Wally was with her on a leash, she would leave her bedroom, she would go to the mall, she would go to a restaurant. I mean, it was just miraculous. And the little boy, God, hated, I can't remember his name. The pig's name. His pig, if he heard the little boy starting to throw a fit, the pig would run in there and sort of, rub up to him and sort of nudge him with his head, and that would stop the fit. And these fits they didn't go all the way to zero, but instead of 15 or 20 fits a day, he'd have like 2, and they would immediately be under control once his pig came in. So enter the HOA. I'm not a big fan of the HOAs. So the HOA found out about these pigs, and in their, what do they call them, covenants and restrictions, they prohibited pigs. And so the HOA sent them a notice saying, if you don't take your pigs away, we're going to sue you. And they did. So they called me after they got sued. Well, so I filed a counterclaim for declaratory judgment, and I sued them for damages under the Fair Housing Act. And my argument was, first of all, pigs are in fact common household animals. I even hired a lady at a pig sanctuary as an expert. She testified in her deposition that, there are thousands of pigs. Newsweek magazine did a story. There 250,000 households have pigs. So that was my first argument. They are household animals. My second argument was, well, okay, even if they're unique animals, we can meet our burden of proving they need these 2 pigs. No other animals worked. So anyway, the story had a happy ending in my opinion. They agreed to a declaratory judgment that the pigs were assistance animals. They could stay there, and they paid me thousands of dollars in attorney's fees. I think they paid me almost $10,000. So now the Fair Housing Act applies to everybody having anything to do with housing: HOAs, cities, lenders, real estate agencies, zoning ordinances. I handled one case against a city in North Texas where my client's teenage boy had chickens. Oops, I keep hitting the button. He had chickens, and the psychiatrist said he really needs these chickens. No other animals work. Anyway, so we sued the city, and we settled with them, and they allowed the chickens to stay. There are no breed restrictions under the Fair Housing Act. I mean, it can be anything. You see the photo here of the man with paraplegia or quadriplegia, and he's got a monkey. Well, that's a good example of this person needs this specific animal because dogs can't open lids, they can't open bottles, but the monkey can. Another big thing to remember is that these animals are not, they're not pets. I mean, you can't call it, you can call them a pet, but the statute specifically says they're not pets. This is, I just threw this in there for a little humor. I love this. I love this little, I can sort of identify with Ralph. He probably shouldn't be a support dog. Okay, workplace. This is Title I of the ADA. Going into public places is Title III of the ADA. The workplace is Title I of the ADA. Or if you're in the Texas statute, it's the Health and Human Resources Code. The important thing here is these laws only apply to an employer with 15 or more employees. If it's fewer than 15, they can just say, I'm sorry, we don't allow service dogs. We don't allow emotional support animals, buzz off. So it only applies to the larger employers. And the law talks about employers have to make reasonable accommodations. Reasonable is a key word. If it's too expensive to accommodate the person, if it's going to cost too much, then they don't need to. The statute says that service animals are a reasonable accommodation, trained service animals. It doesn't mention emotional support animals, but everybody, there's no case law. There's very little case law on any of this stuff, but there's no case law that on emotional support animals, but we think that their employers are probably required to accommodate them. I've had a few cases where an employer wouldn't allow my client's emotional support animal, and I sent demand letters and kind of bullied them into allowing the animals. I've never litigated one of these cases. Well, one. Now, an employer is allowed to ask questions. You remember when you go into a restaurant or a place open to the public, you can only the facility can only ask those two questions. But an employer is allowed to ask about the disability and find out how the animal helps. So tell me about your disability and what does your dog do? Well, I've got PTSD and he'll jump up on me when I'm, starting to have an attack or whatever. So they are allowed to ask questions. They can require a job-related medical exam, to require a medical exam to make sure they can do the job that they've applied for. And they can ask for medical records pertaining to the disability. They can't ask for any other records, but they can ask for records pertaining to the disability. I forgot to mention on housing, if the disability is not apparent, then the housing provider, they can request reasonable information such as a record or note from a healthcare provider, but they can't request medical records, a diagnosis, or medical exam. That's housing providers. I had a case one time where they asked for, this woman was in her 50s and they wanted all of her medical records going back to like childhood, OBGYN, dental records. I mean, there's, and so it was kind of crazy. And anyway, they changed their mind and paid her thousands of dollars after we sued them. Okay, let's talk about airplanes. This is the Air Carrier Access Act. It's a federal law. It's also Texas Human Resources Code. Only trained service dogs, no other animal, no emotional support, no other species, trained service dogs only. No emotional support animals. This is a big change because up until a couple of years ago, federal law, they allowed emotional support animals. And when I used to give this presentation, my PowerPoint had pictures of, actual pictures of somebody's emotional support ostrich, their emotional support 400-pound pig. It was kind of crazy. So now it's only trained service dogs. The airline can't restrict dog breeds. There's a lot of breed restriction people like to do, prohibit pit bulls and stuff like that. They can't do that. The dog has to be on the passenger lap or in the foot space and cannot encroach on another passenger. So those are important. If the dog owner can't do that, then they can exclude the dog. And again, the dog has to be leashed, housebroken, not disruptive, not a threat to health or safety. So they can't jump up and bark or do anything like that. They have to behave themselves. Here's some more rules that airlines are required to follow. They have to they can make the passenger fill out a form. They have to provide relief areas at airports. This relief area, this picture was taken by me at DFW. I thought, that's so cool. Got a fire hydrant in the middle of kind of a lawn. They can't require the disabled person to check in early. They have to give the disabled person a bulkhead seat if he or she wants one. Or if they don't want a bulkhead seat, they have to accommodate that wish. So it's a little easier for an airline to decide if they want to admit somebody. They get to ask a lot more than those two questions. They can ask those two questions, but they can also observe the dog's behavior, look for things like a harness or a vest, or receive credible verbal assurance. So those rules are kind of loosey-goosey. I think it'd be pretty easy to get a fake service dog onto an airplane. So now you know all about service animals. Okay, animal cruelty. This section of my talk is dealing with there's a criminal animal cruelty statute, and then there's a civil seizure statute that allows the seizure of animals that are being cruelly treated. So here's the first thing, the Texas Penal Code. And it's interesting that I was involved in getting this statute passed a long time ago, and the bill that we submitted to the legislature, it was just one statute for all animals. Well, the legislature, in their infinite wisdom, they broke it into two statutes. We've got a penal code statute. We've got animal cruelty to non-livestock animals, and we've got an animal cruelty statute that only applies to livestock animals, horses, cows, pigs. So I'm only going to talk about the non-livestock animals because that's the one I get the most calls about. And the statutes are very similar, except you can be more cruel to horses and cows. So under the Texas Penal Code 42092, it's important to look at the definitions. So an animal, it's a domesticated living creature, including strays, and a wild living creature previously captured. This is really important because when you trap the raccoon that's been invading your garden, you now have a wild living creature that you've captured, and you can't be cruel to him, and you have to provide food, water, care, and shelter. You have to do all kinds of things. You can't confine him cruelly. So the definition of animal is really important. If you think about it, under that definition, really a domesticated living creature could be a gerbil, a mouse. I mean, I've never seen those cases, but cruel manner means it causes or permits unjustified or unwarranted pain or suffering. And then necessary food or water or shelter necessary to maintain the animal in a state of good health. And then torture is any act that causes unjustifiable pain or suffering. So those are the definitions. So now let's look at the offenses. Torturing, here are the offenses: torturing any animal or in a cruel manner, killing or causing serious bodily injury to any animal. That's a third-degree felony, and you can get up to 10 years in prison for that. Now you notice it's any animal. It doesn't have to be an owned animal, because I'm going to talk about this in a minute, but there's a big distinction between animals that are owned, that have owners, and animals that don't have owners. Animals that have owners have a lot more protection. A second crime is without an owner's consent, killing, poisoning, or causing serious bodily injury to the owner's animal. Third-degree felony. Now notice, that doesn't apply to animals that don't have owners. So it's okay to kill, poison, or cause serious bodily injury to a stray animal, an animal that doesn't have an owner. That's not cruelty. And a difference. Here's a real life example. I don't know how many of you read a few years ago, a young newly licensed veterinarian shot a stray cat through the head with her bow and arrow. And then she was on Facebook holding up the arrow through the cat's head with the dead cat dangling from the arrow. And she was never prosecuted for animal cruelty. And I must have gotten a dozen calls. Why isn't she being prosecuted? Well, I called a veterinarian friend of mine, and he said that no, you shoot a cat through the brain with an arrow, it's instant death. There is there's no suffering, there's no pain. So she didn't torture the cat. So what she did was perfectly legal. Now, if an owner came forward, that was my cat. Okay, well then you could argue that she committed a third-degree felony. It's also a crime to fail unreasonably to provide food, care, water, shelter to any animal, including strays or captured wildlife. So when you capture a raccoon or a possum or anything, you are now under a duty to provide necessary food, water, care, or shelter. I mean, shade in hot days. If it's freezing cold, you got to provide shelter from the cold, and care. Um, Cases have been prosecuted where the allegation was you should have taken this person to the vet, and you didn't provide care. Abandoning an animal in a person's custody, that's a class A. Taking a dog out, dropping him off in the countryside, transporting or confining an animal in a cruel manner, that's a misdemeanor, class A, or causing serious bodily injury to an owned animal. There are defenses. If the animal was on person's property in the act of killing or injuring a person's livestock or crops, hunting, trapping, wildlife management are exempt, self-defense or defense of a third person. So you can defend yourself or another person who's being attacked. I love this law. It was passed in the last session, and I was involved in lobbying for it at the legislature. A person convicted of animal cruelty cannot own or possess an animal for 5 years. There was a huge problem with people owning dogs that they were raised for fighting. I mean, really cruel people. People get it. You could literally get out of jail after committing animal cruelty and go buy yourself some more dogs. And you can't do that anymore, at least for 5 years. So one of my favorite things about these PowerPoints is Googling, happy animals and finding pictures for my slideshow. So those are the crimes. Now we also have a statute regarding civil seizure of cruelly treated animals. And this is important because if an animal control officer or a police officer sees animals being cruelly treated, starving horses, dogs, thousands of dogs kept in a hoarding situation. If a peace officer or an ACO thinks that an animal is being cruelly treated, that person can apply to a JP or another judge for a civil seizure warrant, and he can go out and seize those animals. And then there has to be a hearing within 10 days to determine if the animal was cruelly treated. So every time you see on the news, sheriff goes out and seizes some starving horses, or they raided a dog hoarder, and all these dogs were in horrible shape. They're using this statute. It's in the Health and Safety Code, and it's a great law because it helps them get the animal out of the dangerous, cruel situation, where just charging the person with cruelty just isn't necessarily going to do that. So there's a hearing within 10 days. If the judge finds the animal is cruelly treated, judge can order the animal given to a nonprofit rescue or sold or euthanized. The court can also order the animal abuser to pay all costs of investigation, experts, housing the animal. This can be in the thousands of dollars. If the court finds no cruelty, of course, the animal's returned. The owner can appeal these to the county court of law and get a new trial de novo. But the owner has to post a bond to cover the costs of caring for the animal during the appeal. So, okay, so that's animal cruelty. Now, Supreme Court, and it's really a drag to be kind of famous for a Supreme Court case, but not when you lost it. This was my case, and I ruined it for the whole state in 2013. So let me talk about Strickland versus Medlin. Well, I'm right on time. I'm going to have time for questions if anybody's going to have any questions. So what do you get if an animal is killed? If your pet is poisoned by your next door neighbor or shot by, somebody that doesn't like dogs, what can you sue for? Well, here's the Supreme Court history. As you probably know, the general rule of property law is that when property is destroyed, if it's destroyed, you can sue the tortfeasor for the fair market value of the property. If somebody runs a red light, T-bones your car, totals it, you can file suit and you're entitled, the jury can award the market value of your property. Well, and that's been the law forever. In 1891, Mrs. Heiligman's dogs were shot by Mr. Rose. And the Supreme Court held in that, and so she filed suit, went up to the Court of Civil Appeals and then to the Supreme Court. The court held, quote, pet dogs are property, and the owner of dogs that are wrongfully killed is only entitled to sue for their pecuniary value. I don't remember what it was back in 1891, but it wasn't much. So we have a court holding that basically says dogs are just like any other property. I mean, we know that you get market value if your property is destroyed. Well, in 1891 says that applies to pet dogs too. All right, well, things changed in 1963. In that case, the tortfeasor destroyed the plaintiff's, her old wedding veil and her granddad's shoes. They had utterly no market value whatsoever. So she filed suit and said, when property doesn't have a market value, the plaintiff should be entitled to recover the sentimental value of the property. And the Supreme Court of Texas agreed. And the court held that when property has no real market value, then you can sue for the sentimental value. I mean, for example, in 1984, it was a similar case. Intrinsic value of trees that were cut down, the court allowed the plaintiff to recover, even though it increased the value of his land. So that was sort of like sentimental value. And then in 1997, the Supreme Court again came out and affirmed their 1963 sentimental value rule. And they said that where property has no market value, sentimental value may be recovered. In that case, it involved the tortfeasor had destroyed family letters, photos, and keepsakes. Well, those obviously don't have a market value. An example I use sometimes is your wedding album. So your wedding album may have huge sentimental value to you, but you're not going to get anything for it at a garage sale. So sentimental value rule. And that was the history of the sentimental value rule. Now, we didn't have any, after the sentimental value rule was handed down, there weren't any dog cases that went up on appeal or pet cases. But I settled cases all the time for sentimental value. I would have clients come in, my next door neighbor poisoned my dog, and then I would say, well, sentimental value, your dog was a mutt, 9 years old, didn't have any market value. I'd settle a case like that for $3,000, $5,000, $7,000. And my argument was, well, we have the sentimental value rule, Mr. Insurance Agent. So obviously my client's distraught, torn up. And so I used to get good settlements on those cases. And then in I guess it was 2012 or 13, the Medlins came in to see me. I'm doing okay on time. So the Medlins came in to see me. Avery was their rescue dog. Avery was a member of the family. He slept in their bed. He went on their camping trips. he had his own Christmas stocking. I mean, he was their four-legged child. So they came in to see me and they said that Avery had escaped on July 4th because of the fireworks, and he was gone. And then they said what happened was Mr. Medlin went down to the Fort Worth animal shelter, and Avery was there. He'd been picked up. Yay. So they were all excited, and the person at the animal shelter said, well, it's Sunday and we can't release dogs until they're microchipped, and our veterinarian isn't going to be here till Monday. So come back tomorrow and you can pick up Avery after he's microchipped. So the next Monday morning, Mr. and Mrs. Avery and their kids, their two little kids, they bought hamburger and cheese, and they made his favorite meal. They actually put up a welcome banner, "Welcome home, Avery." And then the family piled into the car, drove down to animal control. We're here to pick up Avery. And the lady at the desk said, "Oh, I'm sorry, we killed him yesterday." So they were pretty devastated. So she was apologetic. She said somebody forgot to put the "Do not euthanize" sign on his cage, and we killed him. So the Medlins came to see me, and they didn't care about the money. By the way, nobody cares about the money. In these animal law cases, it's not about the money. Nobody cares. Of course, if you're a lawyer and you derive your income from practicing law, you care about the money, but they don't. And so I told them about the sentimental value rule, and I told them I've always wanted to take a case to the Texas Supreme Court to clarify that, of course, animals are property, but you're entitled to recover sentimental value if they don't have market value. And Avery didn't. He was an old dog, but so I took their case. I filed suit. I lost at the trial court. The judge said, "Randy, I'm sorry, but in 1891, Supreme Court said pet dogs are property, and I see these sentimental value cases, but none of them was a dog case." So I lost at that level. Then I appealed to the Fort Worth Court of Appeals, and and we won. I mean, Justice Lee Gabriel, who's my hero, she wrote an opinion that, well, of course, animals are property, but we have the sentimental value rule. So you get the sentimental value of a dog just like you do any other property. So she ruled in my favor. And as a side note, I was up at the Court of Appeals not long after arguing that case, and I stopped by her chambers because a friend of mine was in there, and I noticed she had a paperweight that said, "Dogs are people too." And that was the bumper sticker on my car. So I thought, okay, so Lee Gabriel's a friend of the four-legged. So we go to the Texas Supreme Court. Here's my argument. Heiligman versus Rose, which decided that dogs are property and you only get the fair market value, that law needs to be changed. Number one, the Supreme Court, after that case came out, 70 years later, held that the sentimental value can be recovered when property is destroyed. Supreme Court have told us dogs are property. So yeah, the sentimental value rule should be applied. A lot's happened since Heiligman versus Rose. A lot's happened since the Supreme Court made that decision that you only get market value. Marconi invented the radio. The Wright brothers invented the flying machine. Women got the right to vote and serve on juries. We're not the same society we were in 1891. We have the sentimental value rule. Don't carve out an exception and say that it doesn't apply to pet dogs. And when I knew one of the justices, Deborah Lehrman. She and I are kind of the same. We started out law at the same time. And I told all my friends, I said, if I lose this case, it's going to be an 8-1, because I've rolled around on Deborah Lehrman's living room floor with her dogs. And I know that I can count on her to not carve out an exception to the sentimental value rule. Well, that's what the Supreme Court did. They carved out an exception. They said the sentimental value rule applies to all tangible property, wedding albums, toasters, mattresses. It applies to all tangible property except pets. And then I know this is sour grapes, but it just sounds like disingenuous. Heiligman remains our lone case directly on point, and after a century plus, we're loath to disturb it. So, and it was a unanimous decision. And I didn't talk to Deborah Lehrman for 5 years after that case came out. And here was another argument I made in oral argument. I said, okay, if Avery had died and he had been stuffed and he was a taxidermied animal that was destroyed, under traditional property law, they could sue to recover his sentimental value, but not when a live Avery is destroyed. And the Supreme Court said, yeah, you're right. I mean, it may sound weird, but that's our holding. So that's the law in Texas. You cannot recover sentimental value for pets. You can for all other property, and which is just a ridiculous holding to me. I mean, people are just incredulous. I had one potential client call me up wanting to sue for somebody who killed her dog, and I told her this story, and she got mad and told me I didn't know what I was talking about and hung up on me, and she was going to go hire a lawyer that knew how valuable pets are. But anyway, that's our law. I ruined it for everybody. I mean, at least before Strickland versus Medlin, we had an argument. We could argue that, well, obviously dogs aren't excluded from the sentimental value rule. Now we can't make that argument. So like I said, I kind of ruined it for everybody. So what does this mean? There is no legal incentive for anyone who cares for animals not to be negligent. None. All other professionals, my sister's a medical doctor. She knows that if she commits malpractice, if she kills the patient, she's going to be liable for all kinds of damages, mental anguish, pain and suffering. So she has a legal incentive to be very, very careful, to not be negligent. But here's who doesn't have any incentive: veterinarians. And by the way, the Texas Veterinary Medical Association wrote an amicus brief against us because their argument was, in their amicus brief, they said, well, if you let veterinarians be sued for sentimental value, jury verdicts are going to go crazy. Veterinarians are going to be held liable for millions of dollars, and veterinarians are going to have to pass that on to their clients. And nobody in Texas is going to be able to afford to own a pet. And that was literally their argument. Kennels, groomers, and trainers. I mean, I would say 3 to 5 phone calls and emails every week from people whose dogs have been killed by kennels, groomers, and trainers, or horribly injured. Doggy daycares, pet sitters, pet sitting companies like Rover.com. An hour ago, I got off the phone with a woman whose dog was beaten to death by a 2x4 by a pet sitter that she got from Rover.com. All she could sue for is the market value of this old mixed breed dog, and it's not worth it. I mean, who's going to hire a lawyer? I mean, unless he does it pro bono or she does it pro bono. I have to tell these people that, most lawyers charge, my vintage, $300 to $500 an hour, and it can be thousands of dollars because the insurance company is going to hire counsel that's going to run the fee way up. So do you really want to spend thousands and thousands of dollars to sue to get a judgment for $50? Pet product manufacturers, I get calls all the time from dogs and cats that have been poisoned by pet food. Pet pharmaceutical companies. I got a call last week from a guy whose dog was killed by pharmaceutical drug. And by the way, I mean, the FDA regulates that and they put out recalls, but there are no damages. So because of Strickland versus Medlin, nobody who cares for or takes care of animals, nobody has any legal incentive to not be negligent. Now, if they do something intentionally, well, yeah, then you can go after them under the penal code. But okay, here's my last plug. So everybody needs to join the animal law section of the State Bar of Texas. We have a listserv. It's humming a lot of times. You know, I've got a case against a groomer. Does anybody have a motion for summary judgment? Here's my plug for the Texas Humane Legislation Network. Almost every single law on the books today in Texas that protects animals is there because THLN got it passed. It's a grassroots organization that lobbies the legislature. I hope everybody joins that. Boy, it's really fun to be part of it. You can be as active or inactive as you want. If you're inactive, just you're a number, and the more people we have, the better. Or you can go down there and testify. You could watch hearings. Anyway, on November 15th, they're having a brunch at the Texas Discovery Gardens in Dallas, where you can meet some THLN people, get involved, find out what it's about. So I guess I have like 2 minutes. I thought I'd have more than that for questions. If anybody has any questions, or else I'll just tell some more war stories.
All right, we actually do have 2 questions in the chat. So we can also, if we go over time, we can officially close the CLE at 1. But Randy, we'd be happy and grateful if you would stay on and answer those questions if you have a moment.
I meant to say that they can only be easy questions, but go ahead.
Oh, I think you got this.
Okay.
So our first question is, do you need documentation to show the airline for service dogs?
No, don't need anything. They can, you can, the airline can ask for credible verbal assurances. They can observe the dog's behavior. But no, you don't need any documentation. If you just show up and your dog is well behaved and you say, this is my service dog, yeah, you're good to go. No documents are needed.
Okay, great. And our second question is, if you have an emotional support animal in an apartment complex and it is approved, can the apartment complex still charge you a pet treatment fee upon move out?
No. They're not pets. Now, if that animal causes damage, you know, you're going to be responsible for the damage, but they can't charge if you rent a place, they can't say, well, we require a $200 pet deposit. No, they can't do that. They can charge if there's damage, just like if you caused the damage.
Well, those are our 2 questions in the chat, and we finished perfectly on time. And we wanted to thank you so much, Randy, for putting on the CLE. It had such important information in so many different areas, and we were really grateful for you to do that. So thank you so much for hosting this for us today.
Well, you're welcome. I had a good time. Thanks for having me.
Thank you. All right, and everyone, Sherry also put the CLE number in the chat, so I'll give it a little bit of time before we turn this off for you to grab that. And just thank you very much. And we have some comments coming in saying thank you, Randy, and it's been really enjoyable. So thank you for all the information. We really appreciate it.
You bet.
Thank you.